Welcome to Ask an Attorney All About Florida Law. Again, I'm Attorney Joe Pippin. If you have a legal question, the law office is open, and we're open every Saturday morning at this time. And all you have to do if you want to ask a question is to dial the magic toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Your question can be just about anything. It can be about wills, trust. It can be about power of attorneys, healthcare surrogates, living wills. It can be about area of law. So if you have a legal question, the phone lines are open. And I am more than glad to be here and more than glad to help you understand legal issues and talk about legal issues. And again, I'm Attorney Joe Pippin, host of Ask an Attorney All About Florida Law for over 30 months or so, 35 years. Longest running show, continual show in Florida, and right up there in the nation too, I'm sure, with long running continual shows with the same host. When you call in, is going to help someone else. Your question is going to make them aware of a legal issue they might be involved in, and they could receive help from you trying to figure out your situation. So again, I'm Attorney Joe Pippin. The law office is open. We practice law in Florida. We are heard all over the country, though. But I'm only licensed in Florida. Can only really give legal advice concerning Florida issues. The toll-free number is 877-943-9673. Abraham Lincoln not having a will, dying, and his estate took over 2 years. A Supreme Court justice took over and finally. He didn't plan anything, though. He didn't plan for his family. He didn't plan personal possessions. He didn't do anything as far as estate planning goes. That many celebrities, Prince died not too long ago, and Prince died without a will. Can you imagine someone with all the wealth, all of the gold albums, all the things, all the money, all the possessions he had, and died without any planning? And when you do that, you leave it up to the state of Florida. So how many people would like to die in Florida that are listening to the show, or anywhere really, and die and not have a plan for your family? Do you want to give one family more than another family member? Do you want to take care of special needs of someone? Do you want to not be able to just give them a whole bunch of money all at once because they wouldn't know how to do with it? Do you want to plan it, control it? Prince died without any estate planning. Just unbelievable. And if you in Florida, if you die without a estate plan, it goes through a statutory probate proceeding. Statutory probate is very expensive. Attorney starts off getting like 3%, goes down a little bit the higher the estate. But there's a large is paid in legal costs. All the money is going to be distributed. And it's just a black and white issue with no planning that goes into that. Let's go to Christina in Arbondale. Hey, Christina. Hi. What can we do? Mm-hmm. Mm-hmm. Well, you're represented by another attorney, so it's unethical for me to get too deep into your question and try to now be your attorney when you already have one. There's a 3-month period of time where you have to advertise in the paper, and creditors the 3 months is creditors to be able to file a claim against the estate. So there's a process of getting that started. You have to satisfy the court, all of their requirements. So I would say easily at least 6 months most of the time. Sometimes it can be a little bit quicker, but most of the time it's 6 months to a year. Yeah, if you get a will contest or some family member that's disgruntled about something and gets another attorney gets involved, and then you never know. It can some estates have been open for years and years and years, just with everybody fighting. Hopefully that isn't the case. The normal would be 6 months and maybe up to a year, I would say. All right. All right. Thank you. It's hard to give an exact answer. Estimate of a good range would be 6 months to a year. All right, let's go to Angela and Kissimmee. Okay. Well, the fence is on your property. What about the ground level? Is that it by how much? How much on the how much of the ground is he taking that's yours? Have you? So the so you don't it's not you have zero lot line. What does that mean to you? It's only 5 feet between the houses. And you said you have a lawnmower, so you have grass to cut. Hmm. Well, I guess you could write him a certified letter, and if that doesn't work, tell him you're going to get an attorney. Then follow up on your promise that you're going to get an attorney to write a letter, and then you try to force him to move it through a legal letter if it takes that much, and then discuss with the attorney your rights on just having the fence removed. So basically, you set a 5 foot line. So if the property in any way is on your property, you could have it removed, and you could put that in your letter, because you own your land, and he can't put anything on your land. In fact, if you don't do something, one day he could claim adverse possession, and possibly he would own the land that he's occupying now. So I'd have an attorney look into it real quick. All right, thank you. Let's go to Frank in the Villages. Good morning. What station are you listening to? Yeah, yeah. We have an office in Fruitland Park. Attorney Patrick Smith, who's on the show about once a month, runs that office. So yeah. Do you have a trust? Well, let me ask you this. Most people say I don't have that many assets, but the assets you do have, including the 2 pieces of real estate, do you want them to go through probate? Yeah. So a trust on almost any size estate, you put the real estate into the trust, and that would avoid probate upon your death. And what should be on the deed? It would just be your name. Are you married? And you and your wife own the property jointly? All right, so when you would die, if you died first, would you want that property owned? We would redeed the properties with what's called a quitclaim deed, and we would deed it from you on one deed to you and your wife as trustees of your trust, and the other deed would be from you and your wife as owners to you and your wife as trustees of your trust. So it would be a quitclaim deed, and that would take care of any probate upon death, and that would also ensure that she would be the sole owner of that property upon your death if you died first. Right. Well, you have other options, but if you wanted to go through if you wanted to avoid probate, the best, in my opinion, the best option is to put it into the trust to avoid probate. So, I mean, there's a ladybird deed. You could do it joint with right of survivorship with another party, which would be a gift, and that would cause possible problems with your homestead. So really, the best and simplest way, and the cost is not that much greater. If you and your wife came to our office, we pretty much have a power of attorney, healthcare surrogates, and 2 living wills. The fee for all of those documents would be around $620. You did a living trust package, it's $795, and so it's only $175 more. But the big benefit. All right, thank you. All right. All right, let's go to Attorney John Frazier. John's a Medicaid VA attorney in our week on one of our shows and get a Medicaid VA tip of the week. So what are we talking about today, John? Good. A person can do to speed things up, or all right. John, I hear a lot of clients think that they have to spend down their money and it's going to take a while, or they get in a nursing home and they have to pay for private care for a long time as they spend down their money to qualify for Medicaid. So basically, if a person had, I'm just going to make up an example here. So say a person has $300,000 in countable assets. Now, homes don't count, primary automobile doesn't count, and there's some other assets. But how long would it take you normally to reorganize the estate and move the countable assets that disqualify them for Medicaid into non-countable assets or non-countable categories? How long does it normally take, just on an average, for you to reposition things so they could get Medicaid benefits as quick as you could possibly do. How long does it normally take? All right, and people also need to know that if they try to gift money away, you always tell people you can't qualify, you can't give everything away one day, qualify for Medicaid the next. Hey, John, how can people contact you if they had a Medicaid question or maybe a nursing home and pay on private pay, and they like to talk to you about that 60-day period of maybe getting everything moved around so they can maximize government benefits and preserve their state? So what's your contact information? All right, thank you so much. All right, you too. All right, let's go to Carlos in Tampa. Hey, Carlos. I'm doing great, and you? I have a full-time family law attorney on my staff. You will or in your will or trust? Mm-hmm. Mm-hmm. Signed in writing? All right, but everything on those papers, Carlos, this is probably going to take too long for us to continue, but now, but we're glad we're prepared. Are they correct in your mind? Is there anything, any room for them to prove something on theirs? All right. Well, listen, I think here's the bottom line. Since your wife now, or your ex-wife, has an attorney, you definitely need your own attorney to what you don't agree with. And Carlos, I see you dropped off the line now, so just call our office if you want to, and ask for Catherine. She's our family law attorney. If you don't have one and want to talk to someone, so the office number is 527. I'm sorry, 727 586 3306. Go to extension 200. Let's go to Susan in Clearwater. Hey, Susan. Mm-hmm. In that area of law, I think somebody's going. You're gonna have to make an appointment with one and take in your condo docs for them to review, and then is probably what's going to have to happen. Yeah, if you want to call my office or send me an email, I'd be glad to try to find the. For anyone listening that would like to have our office information, we don't charge anything for first office appointments. If you would love to mail you a free estate planning poster sheet. So all of the contact information is as follows. You can call our toll-free office number, 1-800-226-3629. The local number for you, Susan, in Clearwater would be 586-3306, extension 200. So in Clearwater, yeah, okay. Thank you very much. All right, bye-bye. You're listening to Ask an Attorney, and the phone lines are just blitzed. We had all 4 lines full there for a few minutes. So we had a phone blitz. Now phone lines are open, so if you couldn't get in during that time, now you can. And our toll-free office number for you to call is 877-943-9673. That's 877-943-9673. Phone lines are open. Hey, and I'm glad to be here, and I'm glad to be able to help as many people as I can. And we're about halfway through the show, and we've already had 6 calls, so need to help a few more people today. And I know you, there's people out there have issues and things going on in their lives, and they don't know the answer. They don't know which direction to turn to. It's bothersome, and they need help or need some advice. And sometimes they just get depressed, not knowing exactly what to do. Hey, give us a call. Be more than glad to chat. And it doesn't cost anything. Ask an attorney all about Florida law. And you have a toll-free number of 877-943-9673. That's 877-943-9673. Phone lines are open, and we are more than glad to help you in any way we possibly can. So if you would like the free estate planning poster sheet, it's a large size poster sheet, double-sided sheet. One side has 5 articles about estate planning. On the other side has all of our contact information. And if you would like it, I'd love to get it to you. So 1 of 3 ways you can do that. You can email me, Joe, J-O, at attypip.com. So Joe at attypip.com. You can call our toll-free office number at 1-800-226-3529. It's 1-800-226-3529. Let's go to JJ in Tampa. What can we do for you? Well, do you have a church? Do you have a church board? Do you have a deacon board? Do you have a all right? So, well, well, yeah. Obviously, you need some legal help, and you probably need an attorney to write a letter to determine what's the status of that money, and if it was proper for the pastor to use it in that way. There's I could give you the name of an organization. It's a Christian Legal Society, which I'm a member of, actually. If you contact my office, I'll give you how to contact them, and maybe they can help you. All right? Well, you just contact me at the office. I don't have all my numbers with me, as I said here at the radio station. But if you contact me, I'll be glad to try to help. All right. All right. Thank you. All right. You too. God bless you. You're listening to Ask an Attorney all about Florida law. Again, I'm Attorney Joe Pippin. Ask an Attorney about Florida law. If you have a legal question, you have a toll-free number, 877-943-9673. Let's go to, phone lines are open, by the way. Let's go to Jane in Clearwater. Mhm. Well, Jane, you have everyone listening to the show has an $11.4 million exemption from federal estate tax. So are you over that? Okay. So you can leave that much to now you sometimes what gets into a question is if you have a large amount of retirement accounts. Well, an IRA, pension, 401k, things like that. Okay, sometimes in the estate plan, when I'm sitting down with a client and it comes up that they want to leave a large amount of money to charities, I ask those type of questions, and sometimes the charities could be the beneficiaries on those type of accounts, because if a person was to receive money from a retirement account, unless it's a Roth IRA or something like that, then they're going to pay taxes on the money they receive, but that's an income tax, not an estate tax. Well, there are built up income on well, those gift annuities, a person gets income, which is taxable, and then at the end of the day, the charity gets it. But what I guess my point is, I'm certain there are some assets in your estate that would be better served giving those to charities, and there are some assets in your estate that would be better tax wise, would be best to leave to an individual. So you can kind of pick and choose what assets do both. But if I were working with you, I would not need a CPA for that. I mean, that's something that I would just normally analyze anyway, and help a client with. And if there was some complicated tax issue that the IRS could possibly get involved, then I could bring in a CPA, or I could conference call with your CPA. That would be normally the way I would handle that. I have one in Largo, which is next door neighbor to Clearwater, of course. It's right on East Bay Drive. It's right on one of the main strips in Largo there on East Bay Drive. Yeah. So our local office number in Pinellas is 586-3306. And extension 200 gets you to an appointment. All right, thank you. And for those of you, bye-bye. For those of you who are listening, we have multiple office locations all around Florida. Our headquarters office, I call it, is in Pinellas County. We have 2 offices in Pinellas. We have 2 offices in Hillsborough County. We have two offices in Polk County. We have offices in Claremont, Leesburg, the Villages. We have offices from St. Augustine to Jacksonville. We have office in Pasco County. And actually, we have found ways to help people all over the state that call us. A lot of times we can interview you on the phone, send you documents through the mail, have further conference calls with you, and then arrange for the signing of documents. You want to call our toll-free office number. It's 1-800-226-3529. Let's go to Pam in Tampa. Hey, Pam. Mm-hmm. How much per hour does she pay your grandson? Yeah. How many hours a week does your son work? Yeah. So I do have somebody I could refer to you that owns a home healthcare uh, service, and they have multiple levels of different types. An excellent job, have a good history. It's helped me with numerous types of clients in that circumstance. So if you want to get that information for me, just call me, and I'll be glad to share that with you and tell you a little bit more about it. So I think it's good to have some family involvement, of course, but your son's going to need a break, and you need somebody trustworthy to come in there and do that. And I think I have the resource for you on that. Yeah, live on the radio right now. So just call my office during the week, and I'll be glad to give that to you. All right, thank you. All right, let's go to Paul in Lake City. It's Joe Pippin. Well, it depends on a number of factors. It depends on how long you were married, what the Yeah, once you are married that long, from 0 to 7 years, there's one category of what generally happens, and then from 7 to I think it's 15, it's another category. Then over 15 is pretty much a split uh, of at least the assets accumulated during the marriage, and then there are certain homestead rights, and it also depends on your income or her income, and a multitude of other type of factors. So you can't. I always like to answer that by saying you can't cherry pick one asset and ask me what's going to happen to it. There are too many other factors that would determine that. now, well, it's possible she have the proceeds of the lot or some portion of the lot. I can't tell you exactly what that would. No, let me ask you this: would the parties could the parties agree if they got divorced on what she would be entitled to? I mean, could he offer her something that she would be happy with? To Mhm. That sounds like, yeah, that sounds like a Medicaid question. Was is Social Security disability? Yeah, something. Well, I see. No, no, no. See, most Social Security disability claims have to be appealed, and it sounds like you get to take that uh, to the next step by appealing it, and the outcome might be different. So you're in Lakes, you're in Lake City. Why don't you call a Social Security disability attorney in your area? If you need any help finding one, I can probably try to help you find one, and see if you get a different answer if you talk to an attorney on that question. Yeah. All right, I would still make a call to a Social Security disability attorney to see if they have a different take on how that can be done, and try to get one that's not going to charge you for the phone call or a free consult. All right, thank you. All right, we have about 7 minutes left in the show. Phone lines are going to be open right after we talk to Tracy. If you'd like to call the show in the remaining moments, it's 1-800 2. Let me see. I'm giving you my office number here. So the number here at the station is 877-943-9673. That's 877-943-9673. And let's go to Tracy in Largo. Hey, Tracy. Okay. Mm-hmm. Mm-hmm. Well, okay. So did he have a bankruptcy attorney during this part? It was an attorney, though, a bankruptcy attorney. My advice would be to go ask him or her that question because mortgages or liens on properties. So unless you've got a satisfaction of mortgage or it's clear in the bankruptcy, so he was discharged in bankruptcy. So the bankruptcy's ended, right? And you have papers that clearly say that the mortgage on the real estate was discharged. Okay. My advice would be to call the bankruptcy attorney and make sure you have a clear understanding of what was discharged and that he still owns the property, outright. And if he does, then he should, well, I would get a reading from the bankruptcy attorney that handled the case. That's what I would do. All right. All right. Thank you. Let's go to Cal in St. Petersburg. Okay. Mm-hmm. Well, no, okay. So you'd put your daughter in as the beneficiary of your house, but you wouldn't put her name on the deed now. Yeah, you would from yourself to yourself as trustee of the trust, and then your daughter could be the successor trustee or the beneficiary, but her name wouldn't be on the deed now as an owner. Yes, yeah, that's what you want to do. You want to do a quick claim deed from you to you yourself. Well, we do this all the time for our clients. Are you a client or just talked to me 30 years ago? Okay. Yeah, so a quick claim deed should be done by an attorney, I'd recommend, from you to you as trustee of your trust to get that in the trust to avoid probate. All right, very good. Thank you. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippin, host of Ask an Attorney for going on 35 years now. And we're here every Saturday morning to answer your legal questions. If you'd like to contact our office, we don't charge for the first review appointment to talk about your what you have and how it could be updated if necessary. We pretty much have all flat fee costs at the website. It is www.attyyip.com. Our toll free office is 226-3529. That's 1-800-226-3529. You can email me at attyyip.com. Again, we have multiple offices all over the state. We have 2 offices in Pinellas, 2 in Hillsborough, 2 in Polk. All of these are on the website, by the way. Jacksonville, Claremont, Leesburg, the Villages, Trinity, Lakewood Ranch, Sun City Center, all active offices where we see clients every week. And again, if you want to contact our office, you have a toll-free number, 1-800-226-3529. And every week we come in with our main purpose is to help people with legal situations and answer their legal questions. And we are more than glad to be here with the awesome opportunity to help people, as many people as we can every day. Hey, Attorney Joe Pippin, hoping you have a great, safe weekend. Be back next weekend, the same time. So long. Cool.